Hello, this is Matt on the Moon Lambo channel. You know what? I was having a pretty good day today up until about a half hour ago, maybe a little more than that. I got a bunch of work done. It was very productive today. Where I live, it's usually freezing cold out here. I'm in the Midwest in the United States, but it was like 60 degrees. I got to walk my pet Peeve, with Peeve being the name of my 5-year-old terrier mix, because I'm hilarious. That's why I named her that. And then, you know what happened? An unsophisticated, knuckle-dragging, mouth-breathing troglodyte named Jay Clayton came along and decided to crap on everyone's day. Look at this. This is pretty funny. So this is Jay Clayton, of the SEC here, and whoever made this, I don't know if it was Ripple Rick here, but it made me laugh, so I thought I'd go ahead and highlight this. But there you go, Jay Clayton. It made it look like a clown. This is hilarious. Jay Clayton of the SEC, he decided that it's time for the SEC to sue Ripple. How about that? So here you can see, here's a headline from the Wall Street Journal. Ripple to face SEC suit over XRP cryptocurrency. So I'm going to run through the news of the day, what this perhaps would mean for us as XRP holders. Is the sky falling? Will XRP deemed a security? And even if it were, what would the fallout be? And so I've got a document from Ripple, the company, and they've already articulated a pretty solid case as to why it's XRP could not ever be reasonably considered a security. So lots to cover here. But before we go any further, ladies and gentlemen, boys and girls, if you would please ever so delicately tap the like button, I'd appreciate the support. And also, if you know that XRP is not a freaking security, go ahead and subscribe to the Moon Lambo channel, because at least you'll be in good company. And I was looking at the price of XRP as soon as I saw this headline, and it just, I guess it developed in the last hour and a half. I was like, I wonder if the price of XRP will go down. And right where I'm circling here, this is about when it happened. And so the answer is yes, it went down a little bit from 52 cents to 48 cents. As I record this, it's like 49.5 cents. So by and large, at least to this point, the market doesn't seem to care a whole lot. It looks like some people did panic sell and okay, whatever, this or that. But it's kind of unexpected. This is indeed unprecedented what's occurring here, but it doesn't mean that there's going to be necessarily serious problems for XRP holders. And to be clear, I don't have a financial background. I'm certainly not offering financial advice of any kind, so definitely don't buy or sell because of anything I say or write, but I think it's an interesting topic of conversation, so I'm going to run through this. Here's the headline from CoinDesk. Ripple CEO warns SEC may sue company over XRP sales. Well, they worded it as may sue. It's a certainty at this point, right? Or do you want to say virtual certainty to be a little safer? Fine, it's happening though. The U.S. Securities and Exchange Commission intends to sue Ripple over its sale of XRP, CEO Brad Garlinghouse said Monday. According to Fortune, the lawsuit will be filed in the near future, though no specific date has been provided yet. The suit had not been filed as of press time. Ripple co-founder Chris Larsen and Garlinghouse will be named defendants alongside the firm, Garlinghouse said. It's an attack on the entire crypto industry and American innovation, Brad Garlinghouse said in an emailed statement. And again, I can't remember if I cited it in my little intro, but Brad Garlinghouse has talked about what would happen if XRP were deemed a security, and I'm going to cover that towards the end of the video. And I'll just tell you up front here, it's not something that is going to stop XRP's actual utility. It's not going to stop real-world adoption. It would just be stupid. But anyway, in an emailed statement, outside counsel Michael Kellogg of Kellogg, Hansen, Todd, Figel, and Frederick said, that's the most lawyery sounding lawyer firm that there could be. Look at that. You just got to slap 5 people's last names together, and then there you go, law firm, man. But anyway, they said, this complaint is wrong as a matter of law. Other major branches of the U.S. government, including the Justice Department and the Treasury Department's FinCEN, have already determined that XRP is a currency. Transactions in XRP thus fall outside the scope of the federal securities laws. This is not the first time that the SEC has tried to go beyond its statutory authority. The courts have corrected it before and will do so again. And I'll tell you, there's lots to consider when going through this. And in the coming days and weeks, as we learn more, I'll be happy to continue breaking it down on the channel. But I've always maintained, for me, a hard break on this concept is, if XRP doesn't have any control over the XRP ledger or the distribution, because mind you, Ripple didn't create XRP; they were receivers of it, so it's been issued. It's already been issued. Given that they don't control that, and they can't shut the damn thing down. Like, to me, that's a hard break. I don't see how you could possibly consider something for which Ripple doesn't have any control because it's a decentralized network. I don't see how you could ever consider that a security. And again, there's all sorts of other factors that can be considered, and once this thing gets to court, it will all be discussed. But for me, that's always just been a hard break. But anyway, Ripple received word Monday that the SEC intended to sue, according to the Wall Street Journal. Ripple is already being sued by XRP investors in a punitive class action lawsuit on claims that the company said XRP's price would rise. That suit, which began in 2018, continues its course through the courts. The company has previously paid $700,000 in fines on charges that violated aspects of the Bank Secrecy Act brought by the Financial Crimes Enforcement Network, which is FinCEN for short, as well as an additional $450,000 in fines to the U.S. Attorney's Office for the Northern District of California. And I've talked about that on the channel before, too. That's not some sort of secret. Garlinghouse's move Monday is reminiscent of how messaging platform Kik announced the SEC would file suit against it for raising $100 million to build Kin. I think they mean Kik. Kik later settled the case. Crypto company CEOs warning the broader industry of upcoming regulatory actions may be a bigger trend. Coinbase chief Brian Armstrong reviewed potential U.S. Treasury Department rulemaking last month, weeks before FinCEN published a proposal for rulemaking. And so, you can say here too, most of this is blocked up. This is the Wall Street Journal article. They have a paywall, but it's okay. I wouldn't want to run through the whole thing anyway. But they wrote here that the lawsuit, which hasn't been filed yet, would be one of the highest profile SEC actions against a cryptocurrency pioneer, just as the regulator's chairman is departing at the end of the Trump administration. The SEC over the past few years has brought and mostly won civil lawsuits alleging startups trampled securities laws when they raised money by selling cryptocurrencies here. And so there's the clown again. On to the next. So here's what, where do we go? I think I need to go up. Yeah, here we go. So here's what Ripple CEO Brad Garlinghouse wrote on this topic. And he wrote this at 7:27 p.m., my time anyway, and as I record this, it is 8:49 p.m. Central Standard Time in the good old Midwest of the United States. So here's what Brad Garlinghouse said. Today, the SEC voted to attack crypto. Chairman Jay Clayton, in his final act, is picking winners and trying to limit U.S. innovation in the crypto industry to Bitcoin and ETH. We know crypto and blockchain technologies aren't going anywhere. Ripple has and will continue to use XRP because it is the best digital asset for payments. Speed, cost, scalability, and energy efficiency. It's traded on 200 plus exchanges globally and will continue to thrive. The SEC, out of step with other G20 countries and the rest of the United States government, should not be able to cherry pick what innovation looks like, especially when their decision directly benefits China. And make no mistake, we are ready to fight and win. This battle is just beginning. And so, like, I have a feeling, you know how long litigation takes, right? I just don't be surprised if this is a process that takes years. This could be seriously a multi-year process. Will not be surprised in the least. But again, even if, and just to be clear, I want to state this too. Just because there's going to be a lawsuit, that doesn't necessarily mean, it wouldn't be the purpose of that particular lawsuit necessarily. We need to see what happens, but it wouldn't necessarily be a potential outcome that because of that, XRP is deemed specifically a security. It could just simply be the case that Ripple, if found guilty of anything, would just get fined again. And we've seen stuff like that too. It doesn't mean that decentralized cryptocurrencies go away just because the SEC sees that this is a security, if they end up seeing it that way. And don't forget that XRP is global. There are all sorts of other major, first world countries and others around the entire world that have said, no, XRP absolutely is not a security. And there is clarity. You can think about over in the UK with the Financial Conduct Authority. They said it's a utility token, right? And so this is the United States, as Brad Garlinghouse said, out of step with the rest of the world, as well as other departments within the United States government, even, as you're about to find out. I'm going to show you some more stuff that Ripple specifically put out on this topic. But I wanted to share this too. Brad Garlinghouse also wrote, Jay Clayton is taking notes from the Grinch this holiday season. leaving the actual legal work to the next administration. Yeah, on his way out, and then he does this out of nowhere. Kind of surprising. Michael Arrington, who is the founder of TechCrunch and Arrington XRP Capital, wrote the following. Those of you gloating over the U.S. government's attack on XRP should take a step back and think about where this all ends. There's no coherence or logic behind these moves. It's spite and fear. And I'm going to illustrate that too. It does not make sense here. Here's a tweet from Stuart Alderodi, a Ripple employee. You can see he wrote here about himself. General counsel at Ripple with over 30 years of legal experience with expertise in banking, regulatory affairs, and complex litigation. And he tweeted out the following at 7:34 p.m. So less than an hour and a half ago at the time I'm recording this anyway. In 2015, the U.S. government concluded XRP was a virtual currency. Last I checked, the SEC is still part of the U.S. government. Here's the plus side. The industry will finally get the clarity it deserves. Goodbye, Howey test. Hello, Ripple test. And I do like that. Now that is something. And so I skimmed through this whole thing. I'm going to go back and read this more in depth at some point. Maybe I'll have more time tomorrow. But there are some points here. I'm just going to just kind of spot check some of the stuff because I think you guys will find this interesting. But this is what Stuart linked to. It's on Ripple's official website. Summary of Ripple's Wells submission. And it's, I can't remember how many pages this damn thing is. It was like 6 or 7, 4. How many pages is this damn thing? It's not that long, so 6 pages, okay. And there's no date on it that I saw, but if you look in the URL up here, it wrote 2020/12, so I'm assuming that this was put on their website December of this year, 2020. And so here you go. The SEC's, maybe it was today. Anyway, the SEC's theory that XRP is an investment contract is wrong on the facts, the law, and the equities. To prove its case amounts to an unprecedented and ill-conceived expansion of the Howey test and the SEC's enforcement authority against digital assets. The SEC's theory that XRP is an investment contract ignores the economic reality that XRP is, and has long been, a digital asset with a fully functional ecosystem and a real use case as a bridge currency that does not rely on Ripple's efforts for its functionality or price. XRP is a currency. XRP is similar to Bitcoin and Ether, which the SEC has determined are not securities. By alleging that Ripple's distributions of XRP are investment contracts while maintaining that Bitcoin and Ether are not securities, the Commission is picking virtual currency winners and losers, destroying United States-based consumer-friendly innovation in the process. This case is distinguishable from the initial coin offering, or ICO for short, and/or simple agreements for future tokens, or SAFTs for short, cases that the Commission has brought previously, which involved no developed ecosystem or established utility for the underlying asset, and where the tokens were sold directly to purchasers by the issuer based on promises of profits and ongoing efforts that were articulated in white papers and other forms. And they do cite a little bit later in this that, and it's true, Ripple never made any sort of promises to anyone regarding the price action of XRP. Let me go a little bit lower. One sec here. I think I wanted to go down a little bit further. One sec here. XRP Ledger. I apologize for a little bit of dead spot in the video, but there's just so much. I don't want to read the whole thing. I'm not going to read you guys 6 pages, all right? I believe that the vast majority of humans listening to this do know how to read the English language. That's going to be my guess right there. I think this is part I wanted to cover, though. Yeah, here we go. Check this out. Ripple is a responsible and transparent actor. Check this out. Years before the SEC's July 2017 DAO report, Ripple relied on expert advice and regulatory pronouncements that XRP was a virtual currency and not a security. In 2015, DOJ and FinCEN settled a case with Ripple and determined that XRP was a convertible virtual currency and Ripple was a money transmitter of XRP. The settlement required Ripple's XRP transactions to comply with laws that do not apply to securities transactions. Think about that. Do you hear what? Do I need to break that down further? Ripple was abiding by regulatory the amount of regulatory clarity provided to that point. They were absolutely abiding by what they were told they needed to do by the federal government. And then you have a different branch of the federal government just giving them the middle finger, saying nope. See, How could that not be an overreach? This is absurd. I think this is not going to end well for the SEC. I'd be shocked, and if it did end well for them, and it's going to result in additional clarity. So in the end, like, if there could be a silver lining, and that would be it. They also cite here, since 2017, around 90% of Ripple's XRP holdings have been held in an inaccessible escrow, which Ripple voluntarily proposed and cannot unilaterally terminate. The escrow is intended to standardize the supply of XRP that would come from Ripple, even during times when the price and volumes of XRP have increased. Well, how about that? And they go on to cite that XRP is being used via on-demand liquidity as a bridge currency. A little bit further, I think there's another spot down a hair lower that I wanted to cover. They cite here also that XRP sales by Ripple were only ever a fraction of volume, so it was rather inconsequential, and that's factually true. That I've been talking about that on this channel pretty much forever. And then here you go. Extensive data analysis shows that XRP's price correlates to that of the other leading digital assets, not to Ripple's announcements or news about its business. The data show that XRP's price has not been impacted by Ripple's public announcements, which means the market does not believe that Ripple's efforts translates into an increase in the price of XRP. And I've been talking about that forever. Whatever you think about it, XRP does follow the rest of the market, and Bitcoin leads it. Now they have this little section about the Howey test. As a threshold matter, it would be unprecedented to bring a case against Ripple based on XRP sales that took place before the July 2017 DAO report, especially in a case where the SEC is not alleging fraudulent conduct. Look at that. XRP is a currency, as the DOJ and FinCEN determined in 2015. Currencies are excluded from the statutory definition of a security. Think about that. It can't be. It's a currency. That's what it's been declared as. Digital assets like XRP that operate as a medium of exchange, unit of account, and or a store of value are properly categorized as currencies. XRP's functional characteristics and long-standing utility as a replacement for fiat currency require that it be categorized as a currency and not a security. XRP trades in a robust currency market with massive volumes of traders, the vast majority of whom have never transacted with Ripple. So there you go. I mean, I think that's the meat of what I wanted to cover. There's a whole bunch more in this, and we'll be unpacking this for days and weeks ahead, and this story's not going to be going away anytime soon. I can pretty well promise you that. Here's a tweet from my fellow XRP YouTuber, Jungle Inc., who wrote, "I highly doubt this lawsuit will hinge on XRP's classification, but rather Ripple's actions raising funds. We've seen other digital asset teams slapped with fines, but the actual digital asset deemed fine for continued use." And that's absolutely true. A fellow XRP YouTuber, Blockchain Backer, wrote the following. The sell-off events in a 9-day period. Flare snapshot, SEC news. Biggest news bomb dropped at bottom of the range last week. Hands shaken out here. Low prices with FUD news get the last ones out. I'm blindly buying, because clearly someone wants me to sell here. I just kind of like that. So into this. XRP deemed a security wouldn't harm Ripple, but might hurt United States, says Ripple CEO. And this is from November 27th, 2020, this year. XRP being declared a security in the United States would not harm Ripple, but might hurt the country's purse, said Brad Garlinghouse, CEO of the American blockchain company focusing on payments technologies. My very strong opinion is that it's very hard to look at XRP as a security, the CEO reiterated during the November 26th Pomp podcast episode hosted by Morgan Creek Digital co-founder Anthony Pompliano. Garlinghouse said he can't think of any market globally or among the major G20 markets that think it to be a security, and declaring it as such in the US would create a larger technological rift between the states and other countries. But if the American Regulatory Securities and Exchange Commission were to say that XRP is a security, a lot of what Ripple does in the United States, we would continue no problem, the CEO said, adding that more than 90% of RippleNet customers are outside the United States. So Ripple would continue to build the business and grow, he said. Still, it's the United States that could be hurt should Ripple decide to leave, the CEO said. We would no longer be a United States taxpayer after paying probably a couple $100 million in taxes, he added. The U.S. regulatory framework said the CEO is out of sync with what other major economies are doing, which prevents it from competing on a level playing field with what's happening in some of these other markets. As positive examples of regulatory clarity, he highlighted the UK, Singapore, Japan, Switzerland, and the UAE. And then there's this piece. I just want to touch on a small piece of this from Cointelegraph on the very same topic. So this was probably the same. Oh, this is November 26th. Yeah, so a day before. Yeah, here we go. If XRP were declared a security in the United States, investors, including Ripple, would need to complete broker-dealer registration with the SEC. So like, it doesn't mean it's going to go away. I don't know exactly what that would look like and necessarily what it would mean for XRP holders, but there will be a lot more to unpack as time passes, so we'll find out. But I just, again, can't imagine this ending well for the SEC, and we'll just see what happens, though. I'm certainly not a lawyer. I just again, it's how is it remotely reasonable for the United States federal government to tell Ripple, here, it's a currency, act accordingly, and then for a different part of the United States government say, nope, just kidding, we're gonna sue you now. Like, how is that remotely reasonable? My gosh. Oh, it's completely absurd. So I'll go ahead and put the picture back. Here we go. There's the clown, Jay Clayton. There we go. I'll wrap up the video with that one. All right. I'm not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next Ripple lawsuit, to the moon, Lambo.